All right, everybody, welcome to the Learning Lab, another installment of the Learning Lab show. This week, we are talking all about estate planning, an incredible outreach from the fans of the Learning Lab, from all of you folks out there eager to learn more about your retirement planning options. Estate planning has been the number one requested thing, and that makes sense considering the situation the world finds itself in right now with this whole pandemic. And so we thought it best to bring on our foremost expert in estate planning, Mr. Brian Benham out of Indianapolis, Indiana. Brian has been working in this retirement space for 30 plus years and has done more estate and trust work with his help of his local attorneys, of course, uh, more than any other advisor or any other Learning Lab representative we have talked to. So, Brian, thank you. Welcome to the show. Thank you so much for joining us and shedding a little wisdom.
Great to be here and great to share some good information about estate planning. And, you just mentioned this being one of the top topics. Just last week, we had a nurse come in, Alex, that works at a local hospital, and she ended up with COVID from working. And
Oh my gosh.
it's interesting. And by the way, she was only 38 years old. And so, good news, bad news. Good news is she was able to come in, or actually not come in, but call us. We're able to work with a local attorney, get an estate plan for her, set up. The bad news was, since she was in a reactionary or an urgent situation, it ultimately may not be the plan or the strategy that long term might be best for her, but it was something because she had nothing. And it was all triggered because of this pandemic. And so it's a great opportunity today. And I'm glad we're going to share some information. This hits home with me and my wife and I. Circumstances we went through. We both had the virus during that time. Alex, you and I had a conversation. I think maybe when I was sick, that I was pleased that I know that I had my estate plan in order. But it didn't change the fact that at my lowest low, I still was making notes about just some final needs, some things I thought my wife might need. So I was in a desperate situation. Good news for me, I'm blessed, I'm fine. But in that certain terrible situation, we become very reactionary, and we need to be proactive with retirement planning. I even for a 38-year-old nice lady that's been a client of ours for a while, this is something I wish she would have already had done. And so to have an opportunity to share some information today is fantastic, Alex.
No, we very, very, very much appreciate it. And, one thing that we always like to do, Brian, if you have some time at the end, is open things up to some questions for some folks. So, folks that are watching, please don't be bashful. Send us your questions during the meeting. We will do our best to answer as many as possible, but we also want to make sure we're covering as much of the information that we had planned for the day as possible. So, Brian, I'm in that on that note, I'm going to pass it over to you. Let's learn about some estate planning. Thanks again.
Great. Thanks a lot. Well, obviously, estate planning made simple, and normally your head slide, you just leave up there for a second, but I do want to make a quick point here. Estate planning is simple. It's not that hard. We help families oftentimes throughout the course of a year where we'll have somebody come in, and I doubt that they spend more than a couple of hours to go through an analysis to determine what their needs might be, answer some questions that the attorneys would have, and then have their estate plan created by an attorney wherever we are around the country. And then by the time they sit down and actually engage or sign their documents, and from start to finish, I doubt that they spend over 2 hours in most circumstances. I'd say 90% of the time we don't spend 2 hours on doing the estate plan. And, I've seen many times most people will spend more time planning a vacation they will with their estate planning. So it is critically important, and don't assume it's hard, because it's really not that hard. Now, as far as the presentation is concerned, disclosure, recognize that we're speaking to people all over the country through this opportunity we have today. Know that I'm not the attorney. I'm just going to share information of general nature. I'm not trying to dissect or analyze any one particular person's situation. If you want a copy of our disclosure, feel free to contact us. But I'm not your attorney, your tax person, your financial advisor. I'm not that. I'm just going to share information, and it's based on opportunities that I've had over the years and situations that I've come across, either myself or my staff. And as you mentioned, I think we are nearing the 6,000 mark of estate plans that we've helped people over the years create, and it's always been done through the help of a local attorney, and that's critically important. What our organization is not is a trust mill. Learning Lab is not a trust mill. We're an educational source, and we try to plug folks into situations where local attorneys are obviously involved and can help create any legal documents that would be needed. But through our network of Learning Lab advisors across the country, they've all been trained in our system. They all understand what I'm talking about today. They too have had opportunities to help many, many people sit down and recognize the importance of estate planning. And so if you're viewing this, know that you're not on your own. You're not alone. We have advisors all over the country that can help you take care of any estate planning situation that you have or may have, or you might recognize through this presentation. So that's who we are and what we really are all about. You know, why are so many people not prepared? Well, just like this nurse, here she was in a category where in that Generation X, where 64% of people do not have a will or any legal document whatsoever regarding their estate plan. Almost 60% of all Americans don't have any estate plan, and I think 40% of people over 53 or so, don't have anything. And that's an alarming statement for me, especially that last one. 40% of Americans over 53. We have a tax office as well. We'll have a couple thousand appointments a year during our tax season normally. And it still surprises me in our own database of clients, the high number of people that don't have any estate plan whatsoever. And so over the last several years, even though everybody listening would assume all my tax clients have estate plan, we had to make a focus because we have so many new clients every year. We had to make a focus to make sure that they were in a situation where they had an estate plan, or we tried to point them in the right direction to make sure that they could get that done as well. Now, what are the essential documents when it comes to estate planning? Now, the first thing people think of is a will. Always, I need a will, or I have a will. Well, then there's the trust. And somebody will say, well, I don't need a trust, or my estate's not big enough for a trust. No. Don't think that. We're going to talk about pour-over wills. That's also could be an essential document. Financial power of attorney. Who's going to sign your checks if you're not capable anymore? Who's going to make healthcare decisions if you can't speak for yourself? Who becomes your spokesperson if you're not able to speak for yourself because of a health condition? That's what we're talking about on the essential documents today. What is a last will and testament? Well, a last will and testament is basically an expression of your wishes that the court will deem to be accurate or not someday, and we call that a will. A will is actually a document that is created. It's signed by you. It's witnessed by a couple of people. And like I said, it's an expression of your wishes. Now, a question I ask a lot of times is, when does that will become valid? And everybody says, well, as soon as I sign it. And some people might say, well, as soon as I sign it and as soon as it's witnessed. Well, actually, it doesn't become valid until after you die. See, probate is a legal process designed to transfer title from a deceased person's name into the name of a beneficiary. Now, just what is that instruction list? What is that chart of events that you want to take place from the time you die until it passes on to your beneficiary? You're the deceased. We have to change title in the name of a beneficiary. Well, that instruction sheet is the will. And at your death, that's when the probate judge would probate or agree upon, it's a Latin term, to agree upon. That's when the probate judge would agree upon your will after it's reviewed by the court. And that starts the process of probate. Actually, that's called spread the will of record. That's when you die, you present the will to the court, they spread the will of record, they start the process of probate, and the family has already probably hired an attorney because this is something they don't normally do, so they pay an attorney to use the local probate court to help settle the estate using the will as the instruction sheet. Now, sometimes somebody might prepare a letter because they don't fully understand their own will, and they might say, hey, judge, here's what I really mean. Here's what my thoughts are. And sometimes a judge might use that, or maybe somebody would write a letter to the judge or write a letter thinking that it might change your wishes in probate, something to the effect that I'm just not sure that my third son is capable of having a lot of money. Judge, would you use your discretion? my goodness, that's a nightmare waiting to happen. But I've seen people do that. Maybe a will, last will might be used to name or appoint, or name a guardian for minor children. In our situation, we had to go through a guardianship process for my stepson with special needs. A will couldn't have done that because it had to be approved by the court in our situation. And I'm going to talk about that in a little bit, but that was a unique situation because he's not capable to speak for himself. And even though I provide a home, I take Jack on vacation, I pay for his food and do everything for him. The day he turned 18, we lost the legal right to make decisions for him. And my wife actually had to go through a guardianship. This is crazy, a guardianship, so she could be her own son's with special needs legal guardian. So that's something else we're going to talk about when we talk about power of attorneys. And then obviously a will is designed to outline the distribution of your assets. Now, if you have nothing in the way of estate planning documents, a will is wonderful. Don't misunderstand me. And some people just need a simple will. But there are different things that you might use to help plan for your estate. And one of the tools that we've been very involved with helping people is something called a trust, a living trust. Typically, you might hear the term revocable living trust. And I think most people know that revocable means changeable. So if I have a changeable living trust, that during my life, that allows me, the creator, to change it, or the trustee to change it. And that's what a trust does. Now, with a trust, if I have trust assets, those are usually outside the scope of probate. Well, guess what? If I have a trust and my assets are in the trust, they're outside the scope of probate. So my kids don't have to relive my death every time they walk up the stairs of the probate court because I left my affairs in a probatable situation. So we'll talk a little more about that. Generally, trust assets or trusts are considered much more difficult to attack in court. Now, I will tell you, I think that's one of the best things about a revocable trust. Oftentimes when I talk to people about the concept of a trust, I go back to, when I was I think it was in junior high, I had a semester of business law. And I remember in that class, we talked about contracts. And one of the things about a contract was there's two parties to every contract. And let me give you all a tip about this real quick. If any of you have a life insurance policy laying around someplace, go open up that life insurance policy and open up the first page or two, and it's usually signed by the president of the insurance company. That's one party to the contract. And then if you'll look towards the back of your contract, you'll see a copy of the application. And guess who signed that? You did. There's the two parties of that life insurance contract. Now, the insurance company cannot change anything once they made that promise, and you are the only person that could change anything since you're the other party to the contract. But if you die, there's no provision that would allow anybody to change that contract. So, for example, if you listed beneficiaries on that life policy and you pass away, the life insurance company has to follow the instructions you left because it's a contract. Well, a living trust is actually a contract. Just a minute ago, I said that if I created a trust and I wanted to change it, I can. I'm the creator. You see, in a revocable trust, there's two parties. There's a creator, and that might be Brian Benham. I created the trust. But once I created the trust, I wanted to hire somebody to manage the trust. Well, guess who I hired? It's my stuff. It's my house. It's my money. I hired myself to be the trustee. Even though Brian Benham is Brian Benham, grantor or creator, he's also Brian Benham, trustee, two parties. So I'm both parties of the trust. If I would pass away, who's going to change it? The courts assume that since I had a chance to change my trust, since it's revocable, all the way up into my date of death, then they assume that I died having expressed my most current wishes. That's why you don't see a lot of trusts changed. And to my knowledge, we've never had one changed. And we've helped many, many people over the years do a revocable trust. Now, why is that important? How many times have you folks run into a situation where you knew somebody that had a child that maybe wasn't prepared to receive a huge inheritance? Maybe you ran into a situation where you had a child that ended up in jail. and he cost the family a lot of money. And mom and dad decided that, hey, we spent all this money to try to get him out of jail or pay for his legal counsel. We don't want to leave him any more money and shortchange our other kids. So they disinherit that child. Now, on down that road, whenever you finally pass away, that child might still think he deserves something, when really he doesn't. He might try to contest a will, and a contest of a will would be heard by the probate court. And by the way, if it's going to be held by the probate court, there's going to be attorneys involved, and the attorney fees are going to come out of the estate. That's one of the reasons why probate costs so much. But with a trust, you've expressed your wishes. And there's sometimes something called a poison pill. And a poison pill might say that, hey, if that one child who gets very little or nothing tries to contest this trust, they then would get absolutely nothing. Sometimes you've heard of people leaving maybe $1 to somebody. Well, in that situation in a trust, if that person that received $1 contested the trust, the poison pill might say not only do you not get anything, but you're not even going to get the $1. So there are things that you can do with the trust. Isn't that crazy? The things you can do with the trust that are very impressive and allow you to do something that I've taught for years, to have controlled distributions. And sometimes controlled distributions are the best thing for the kids, but the kids may not like it. Maybe the trust is set up to only give you 10% a year for, say, 10 years, and you wanted it all. Well, sorry, mom and dad set that up so that you would be disciplined. So there are things you can do. And another one would be to provide privacy. And Alex, you've heard me tell this story before, but I remember about almost 30 years ago, I sat down with my grandmother and grandfather, and very private family. And I told Grandpa, I said, look, your will's going to be a matter of public record. And after you die, I could go down to the court and take a peek at who got what, who got the house, who got the cars, who got the rental property. And then I went on to talk to him about all the other benefits of a trust. And we were in our conversation for about 45 minutes. And Grandpa looked a little puzzled. And I said, Grandpa, what are you thinking? And he said, did you say my personal stuff is going to be made public after my death? Now, the point was, I talked for 45 minutes after I told him that. He didn't hear anything else. The idea of his matters being public down at the courthouse is all it took for him to know that he wanted to do a trust because it remains private. If you question that, folks, just go to your local courthouse, walk up the stairs of the courthouse, and go inside and ask where they keep their probate records. And they'll typically go open a door and say, go on in there and just pull out these great big volumes of books and start going through and flipping through these pages. And you'll see all the records of the probate court or cases that have been settled in that local court. I've done it several times just to look things up because it's public record. A trust is not made public. The only thing of a trust that might be made public would be a copy of a deed that would say, hey, Brian Benham has a trust because his property is held in that trust. There are a lot of people have failed in this. I remember many stories when I was first being trained about estate planning. One of the biggest stories that I was interested in at the time was Elvis Presley. When Elvis died, he had about $10 million, believe it or not. Now, that doesn't sound like a lot, but he died way back in 1977. By the time you get through the tax problems, the probate problems, and all the contests and issues surrounding his estate, he only ended up with about 73% of his estate was consumed in fees. Now, I would guess that his estate is worth way more than that today. But as far as the probate was concerned, he was a great example of somebody that made mistakes. Now, I'm not here to say who did what right or wrong, but I do know he had a will. He didn't have a trust, but he might have died thinking he had a trust. And here's a tip for everybody too. He actually had a will that inside it had a trust. It was called a testamentary trust. And a testamentary trust is a trust that is funded with assets after they went through probate. Now, think about that for a second. Think about an attorney who created a will and got paid for the will, has the client go home thinking they have a trust, which is true, but the trust isn't funded until after you die, and probably who created the will gets to probate this and gets paid to take it through probate, and then the assets go into a trust, and then that testamentary trust would then distribute onto the beneficiaries. I've always thought that's kind of the best of both worlds for the legal side. I don't think it's necessary in most cases. Now, in some cases, maybe there's a reason for it. But for today, just imagine, what if you had a revocable trust, and while you were alive, you put your assets in it, and at death, there would be no probate? Isn't that what you're looking to do? That's not what happened with Elvis. Now, with the living trust, as I mentioned earlier, there's a couple of different roles that people serve. There's a grantor, that's the person that created it, and I already mentioned that a few minutes ago. And then there's a trustee, a person or a company, typically person. I had a gentleman in my office just last week, and he's in a situation that when he dies, he has no beneficiaries, no children, and his assets are going to go on to some charities and to nieces and nephews. And I asked him, I said, do you have a particular niece or nephew that you have faith in that could serve as your successor trustee? Because if you don't, you're probably going to have to hire a bank. And I typically don't like that because they can be quite expensive, especially when you're looking at 3-4% per year over every year for whoever knows how long. And then we have the beneficiaries. That's the third party to the trust. Now, another thing I always like to mention, the first beneficiary of a trust is you, whoever created it. It's your stuff. You're going to receive the benefit of it. But your focus would be on the beneficiaries after you. And that, in my case, would be my 5 children. And that's how our trust is set up. Now, we also are going to talk about the power of attorney. Power of attorney and executor of a will are things that most folks think about. The power of attorney is not the executor. It's 2 different parts, different people. Power of attorney usually can make decisions depending on your state, on just financial. And then there's also something called a healthcare directive in most states. Power of attorney is a critically important document. A few minutes ago, I talked about my stepson and how when he turned 18, we had to go get guardianship. And I made a comment that he wasn't able to speak for himself. Here's one of the biggest things I found about power of attorneys that people don't recognize. Sheila and I have been married for several years, and I don't know that anybody knows her better than me. And I don't know that anybody knows me better than her. So if something would happen to my mind and I wouldn't be able to make financial decisions, I'm confident that Sheila would know exactly what I would want done. Or if something happened to her, I'm confident I know what she would want done. The problem is, if I lose my mental capacity decision, who has the right to make that decision for me? Her because she's my wife? No, not at all. Not in the eyes of the court. If I don't have an instrument created that details who I want to make decisions for me regarding my finance, then Sheila would have to go through guardianship for me, her own husband. Just the same process of guardianship that we had to go through with Jack, because I wasn't able, or Jack wasn't able, to speak for himself. So to avoid that, while we are alive, while we are not just alive, but while we are capable to make decisions for ourselves, how about I simply tell an attorney that, hey, why don't you create a power of attorney for me and list my wife as my power of attorney? I'll pay you $50. Let me sign that in front of a witness, or depending on your state, let me have it notarized. And guess what? That little indication of what my needs and wants were, that little signature I put on the financial power of attorney, completely eliminates a couple $1,000 fee and requirement to go through a guardianship process. Folks, even your spouse doesn't have that control. That's how important the power of attorney is, and too many people just assume that they're married, that gives them the right. No, that's not the case. Banks need to have power of attorney. If anybody else is going to act on you or your wishes for you regarding finance, you've got to be able to, or you've got to have a power of attorney, just period. Other commonly overlooked issues in estate planning: people do not update their beneficiaries like they should. I've had many situations over the years where we'll have children listed only to find out one of the children had passed away. And what do? Do you pass on those assets? Do they follow their bloodline onto the kids? Is it going to go to the in-law that you may not or may not like? There's a lot of questions there. You've got to designate somebody to act for you regarding your estate plan. Now, that typically is going to be your trustee or your successor trustee in the trust. Executing up-to-date power of attorneys. I typically like to see a more current power of attorney than something that was done 20 years ago. I've seen power of attorneys contested because they were so old. Same way with living wills and medical directives. These change, and they've changed many times over the years. I know here in Indiana, our living will today looks completely different than it looked in 1990, 92, 94. Not updating asset ownerships, failure to fund revocable trusts. not coordinating trust with retirement plans. Now, what do I mean by that? Let me go back to point 6 there. Picture with me, if you will, a box. And let's call this box the Benham Trust. And on the outside of the box, I have all my instructions. It says I'm the trustee and Sheila's the trustee. And if something happens to us while we're still alive, Kyle, my oldest son, is my successor trustee. And if something happens and we pass away, or when we pass away, Kyle would serve as the successor trustee. And he would be in control of everything inside the box, only to act on our wishes, not change them. And the rest of the box has all of our other beneficiaries listed there, so we know who's going to get what and what percent. Now picture with me the inside of that box. What do you see? Well, there's nothing in there. I've got great instructions written on the box. I've got my plan written on the box, but my box is empty. There's nothing in the trust. So when we look at point 6 here, failure to fund a revocable trust, how do I fund a trust? Well, as I mentioned earlier, my deed down at the courthouse is the only indication publicly that I have a trust. That's because my deed doesn't say Brian and Sheila's house. It now says this house is owned by the Brian and Sheila Trust. So now when I look in my box, I actually see my house is in there. And I can change my bank accounts into the Benham Trust, which we've done. So they're inside that box. Our personal property is inside that box. Sometimes even our cars are inside the box. Our stocks, our bonds, our investment account is inside the box because it's all listed in the name of the trust. That's what we're talking about. Some people might go to the extent of creating a trust. And folks, I'm going to tell you, I bet I've seen 500 unfunded revocable trusts written by very competent attorneys across the country, but nobody took the time to sit down with these folks and explain the importance of funding the trust. So it's not just creating the document, it's getting the stuff in it. Coordinating trust and retirement account. I might have a nice trust with my house in it, but I might have all my assets, $500,000, for example, in an IRA. Well, what if you have special distribution plans for that IRA? Maybe you don't want it to go just to your kids as soon as you die. Maybe you want to stretch it out. A trust might be the device, a conduit trust might be a device to control that distribution. So there's all kinds of mistakes that I see that are critically important that we want to let people know that these can all be handled when you talk to a Learning Lab representative. They've been trained in all the areas to try to help keep you or help you to avoid some of these common mistakes. Now, I can sit here and talk about them all day long, but everybody's situation is different. And frankly, it takes an individual relationship with somebody that understands what to look for. Whenever I talk to people, I call it fishing. I sit down and I ask them all kinds of questions. You know, I know you got a house and you got a couple of cars. Do you have a boat? Do you have a motorhome? Do you have an airplane? You know, I'm always fishing, trying to find assets that should be funded in a trust. And usually I don't, but every once in a while I say, well, yeah, I have an airplane. What does that have to do with it? Well, we've got to get it in the trust. Or do you have property out of state? There's so many questions that our Learning Lab representatives have been trained in that will help you, whoever's listening to this, that will help you make sure that when you take the time, which you should, to create an estate plan, that it's going to be properly done. And then they partner you with an attorney in your state to make sure everything is done properly and created by a competent attorney. Marilyn Monroe made a huge mistake. You know, she had a business manager that questioned what she did when she created her will. And not only did she, or when she created her will, she created, I think she gave 25% for her psychiatrist and 75% to her like a choreography manager, if you will, who quickly died. And this person that she'd only met, I think, once, the spouse of this manager she had, ended up with 75% of her estate. Can you imagine the value of Marilyn Monroe's estate over the past 50 years, 49 or no, be 57 years? Can you imagine the value of that? I'm sure that's not what she intended. Isn't that crazy? But that's what happened. Again, I don't know whether you have as much as Marilyn Monroe or Elvis Presley, but let me tell you this. I don't care whether you have $1 or $1 million. You should sit down and get your estate plan in order. Now, one of the things that I found when it comes to a trust, a lot of people think I don't need a trust because my estate's not that big. Well, let's talk about something. In most states, a $100,000 house would get stuck in probate. And almost in every state, a $150,000 or $200,000 estate would get stuck in probate. So once something's stuck in probate, any value of say over $100,000, in some states as low as 50 or so. When you look at the house, the cars, the personal property, the money in the bank, it's easy to trigger probate. The size isn't that important. It's what you're trying to accomplish. If you're trying to accomplish a device that would pass the control over to your children instantly at your death, and not shift control to the courts, then that's probably going to be a trust. If you want to keep your estate private, then it's probably going to be a trust. If you want to control distribution or have a speedy distribution to your children, not delayed and administered under the guidance and direction of the local probate court and the attorneys involved, then you probably would want your children to be in charge. You know what a revocable trust has always been for me? It's been a device in which I'm able to pass on my estate through the most common sense approach imaginable. It's my stuff. It has nothing to do with the probate court. It has nothing to do with an attorney I don't even know. My children know what my wishes are. I want to be in control till I die, and I want my family to be in control. Folks, think about that. Is that unusual? Is that something that you wouldn't want? Doesn't that make sense to you? Well, folks, probate is not that. That is not how the probate system works. A common sense approach to an estate plan could be something as simple as a revocable trust. Now, I can't say it's appropriate for everybody. I think it is in most cases. But just recognize that's just a common sense approach to how I want my estate settled. And for me to be able to do that, a trust is the best device for us. I don't want some stranger down at the courthouse making decisions on how they're going to help pass assets on to my kids when I know I want my kids to get it anyway. So when you create a trust, you basically pre-administer your own estate so that you make all those decisions while you're alive, not decisions made by an attorney you don't know or a probate judge you don't know. Whenever I create my trust, I make my own decisions. I say who gets what. I say who's going to be in charge, and that's how the system works. Now, this particular slide we're looking at here talks about what can be passed on to our loved ones without any tax. And frankly, I'd say 99% of all Americans today can pass on everything without any death tax because our exemption, the amount of money we can pass on to our kids, has been raised so much during my career, and you know, it was under 600,000 at one time. Then it was about 600,000 for several years in my earliest years where I helping people. But that amount has gone up to now, as of 2019, to $11.4 million per couple can be passed before there's any estate tax. Now, folks, that has nothing to do with a trust or a will. That's just the estate value that can be passed without any death tax. Can you imagine somebody having an $11.4 million estate, what the probate cost would be if they didn't have it in an estate plan? Are you serious? In a trust, probably. Can you imagine that? How about this? How about your estate's only worth $200,000 or $300,000? That's still a lot of. That's it. That's yours. That's everything. Can you imagine the amount of money an attorney might charge to drag that through probate and stretch it out for a year or year and a half before your children have complete control? How does that make you feel? You know, I remember back in the late 90s, USA Today said that probate cost an average of 5 to 10% of the gross estate value. If you had a $300,000 estate and you got a good deal, 5%, according to the USA Today, that'd be $15,000 consumed in legal fees and probate expenses before your kids took control of your estate. Is that the common sense approach that you had in mind? Probably not. You could spend maybe $1,000 or so, or maybe less than $600 or $700 or $800 to do an estate plan using a trust. A little bit more cost than a will, but guess what? If it's done right, that avoids probate. Kind of makes sense, doesn't it? That's what people need to recognize. It's a great tool or great device in most situations, so it ought to be a consideration. As far as estate taxes, for right now, I'm not too concerned about 99% of all my clients because they're under that $11.4 million tax plateau. However, didn't we just see a couple of $1 trillion given away because of this pandemic? how are we or our children going to pay this debt in the future? Are they going to raise taxes? Do you think they might lower that exemption again in the future? It's something I know it's already being looked at, so this could be a consideration on down the road. So we just talked about estate taxes. What is probate? We've kind of danced around that. Probate is a legal process to pass assets from a deceased person to the name of their children. I've already mentioned it's time-consuming, expensive. I've already hit on a lot of these things, but it could be completely avoided by doing a trust or other ways you could pass it on. Now, there are some other considerations. Non-retirement plans sometimes through banks have PODs or TODs, pay on death or transfer on death. Retirement plan assets, typically 401ks, IRAs, TSPs, these financial tools have named beneficiaries. Annuities, life insurance, named beneficiaries. Kind of sounds like contracts, doesn't it? Yes, it does. Real estate assets. Sometimes in lots of states now, you might be able to put a transfer on death, or they might call it a beneficiary deed. There are some ways to avoid probate now through different courses, but I still like the concept of a trust because you have so much control with the distribution. And we'll touch on that again in a little bit. Various different ways. Non-retirement plan financial accounts. Going back to banks, I touched on this, transfer on death accounts. I know that a lot of financial accounts are called TOD accounts through financial institutions, brokerage services. Those are usually non-qualified accounts. However, those are limited depending on the institution. I mean, I've had one bank have one approach to a transfer on death, and I've had a credit union down the street has a completely different approach to that. So you've got to know your institution and know what their terms are. Now, again, you might have 5 or 6 different bank accounts, and you might have POD on them, and you might think you're fine. Whereas if you would have had a revocable trust, the trust could have controlled that, and there would have been no issue with transfer on death. So there's lots of different things, but this, again, is important that you sit down or circle yourself around somebody that understands estate planning, and like one of our learning lab representatives could help you on that and determine what is best. No sense to do something if you don't need it, if there are other ways to get things accomplished, but just make sure you're clear that what you're trying to get accomplished can happen in your area. As I said earlier, IRAs, Roths, these have named beneficiaries. I touched a few minutes ago about missing or inaccurate or out-of-date beneficiaries. That's a critically important. I know I created an agenda just this morning. I'm helping a federal employee that just retired, and now we're doing her retirement planning. We're doing her estate plan. And I know that the very first question on my agenda discuss, I don't know if you all can see this, but my agenda is discuss estate plan. Number one. Now, we're talking about financial, but my number one discussion is discuss the estate plan. Do you have those affairs in order? So these are all critically important things, and she's got me and a learning lab representative. We're going to be talking to her about that. Annuities, life insurance passes tax-free, named beneficiaries, trust can be a beneficiary. Let me give you an example of a situation we just came in contact with just this week. I actually mentioned this gentleman a few minutes ago, but I have a fellow that has been a lifelong client of ours, and his wife died April 14th. Unexpectedly, it was not because of the virus. I assumed it was, but it wasn't. But they don't have any children. They have nieces and nephews, and it's a sizable estate. It's going to be about $2 million. Now, he came in just the other day, and we're having an attorney create an amendment to his trust because he loves his nieces and nephews, and he threw in a few grand nieces and nephews, loves them too, but he doesn't have faith that they should receive as much money as they are going to end up getting all at one time. That's the key. There's also 3 charities that are involved. So what he's doing is he did an amendment to his trust. Now, by the way, imagine trying to do this through the court. Imagine trying to do what I'm getting ready to tell you and pay an attorney $300 an hour to administer this. But through his trust, he elected his successor trustee to continue managing the trust after his death. And on the birthday of all the nieces and grandnieces and nephews, all the nephews, she's going to be writing a check for their share. It's going to be 1/12 share of $100,000 that they're going to designate per year to be distributed. So on everybody's birthday, they're all going to get a check in his and his wife's name in their honor to help them, and it's a controlled distribution. And then on annual basis as well, these charities will get a share of that. And that's going to run basically until it runs out or until the 20th year. And then whatever's left will then be distributed equally per share to all those beneficiaries. What a great tool. What a great tool. Yeah, you like that, Alex? I mean, how many times have you heard of a child receiving a big benefit and it's gone, you know, in no time? 80% of inherited wealth is gone in 14 months. 80% of inherited wealth is gone in 14 months. It's crazy. So that type of tool is fantastic. Qualified terminal illness, I'm going to kind of speed this up so we can get it wrapped up. A qualified terminal illness participation is another Q-tip trust. This might be, let's say I'm remarried and I want to take care of my new wife if I die first, but I don't want to lose or let her have control to spend everything and not give it to my kids. So maybe I create a Q-tip trust, which allows my wife to continue the same level of income and lifestyle, but at her death, then everything passes on to the kids. Different types of trusts, all types of different things that are out there. Estate planning for qualified accounts. I just touched on this a few minutes ago. I love the idea of it's the slang term's a conduit trust, but to be able to control distribution on qualified accounts. In most cases, that's where all the money is anyway. And so you might have a trust involved to help create a plan of distribution so that you don't hand over $500,000 to one child and have it potentially lost in a matter of no time. What do we see? Excuses, procrastination. This is the biggest one. People just aren't concerned. 38-year-old nurse never dreamed she might die. So she never worried about it. She always put it off. Now it's a reactionary situation. Confusion. This is probably the biggest thing. People just assume that my wife can make decisions for me or I can make decisions for her. There's no way my estate's going to go through probate. My attorneys told me that my estate will not go through probate. My attorney told me that since I had a will, I would not go through probate. Alex, you know that's true, right?
So
it's true because you're going to be, you're going to be dead and gone. You won't go through probate. I'm sorry, Alex, I didn't mean to set you up there. But yeah, I've had people tell me or say, well, my attorney said I won't go through probate. And I said, that's true. Well, you just said I would. No, I didn't. I said your estate will go through probate. You'll be dead and gone. It's your kids you're forcing through probate. So a lot of folks just assume, no, I won't go through probate. That's what my attorney told me. That might be the only true statement you've ever gotten from that particular attorney. But it's your kids. Don't want to talk about it. That's another big one. That's whenever whenever you talk to I talk to my kids and they say they don't care, whatever. You know what their kids are saying? They don't want to deal with it. It's up to you to deal with it. It's your responsibility. There's a couple of different things that you consider when you're thinking about estate planning. One is a will plan. Our local learning lab representatives across the country have an easy, seamless way to create an estate plan to fit any situation. There are basic will packages. And I said sometimes that's all you need. It might be appropriate, but at least you get a power of attorney and you get your healthcare representatives and you get everything set up there. Or maybe it's a trust package that works best for you. Or maybe there's what we call a plus package that makes it even easier for you to create an estate plan where you're on the phone directly with the attorney and the counsel to get everything set up. Recognize how simple this is, but focus on the importance of circling yourself around somebody like a learning lab representative who has been trained in this stuff. Folks, this is critically important. I know I touched on this earlier. I'm going to focus on it again one more time. I felt like I was completely prepared with our estate plan, our revocable trust, and our special needs trust, and all that we have. But there were still things that I was worried about whenever I was scared that I may not make it through this last month. But the bottom line is, we were in a position now in hindsight. I'm so far ahead of most people because we have taken the time to create an estate plan. Doesn't mean that everything has been decided, but at least we have a foundation. Do you have a foundation? Have you taken time to set anything up? And statistically speaking, most of you haven't. But folks, one of the first things I said, the very first slide, it's not that hard. It's simple. Just get your affairs in order. With that, I'd like to just kind of reinforce what I've said 2 or 3 times. Take a few minutes to fill out a survey that's going to be provided in this session, and we'll partner you with a local learning lab representative that can go through everything that we've talked to here today. Alex, I think you mentioned we might have a few questions that popped up today. Do we have any, or do we have time for a few?
We definitely have time for a couple. Obviously, we went a little long, but great information, absolutely necessary, especially on a topic like estate planning. And right now, considering the environment we're in, we'll touch on that survey. The survey will pop up as soon as we conclude here. But first, I just wanted to get to a couple of these questions. Um, so one of them is coming from a nice lady from the Midwest named Jane that was wondering if we, well, let me see if I can decipher this real quick. If we get a trust, if I were to get a new trust, what would happen to my old will? I think does that make sense to you?
Yeah, absolutely. I've had that question hundreds of times. There's two answers. I'm going to give you one real quick first. If you picture everything that you have in your name individually now, your house, your car, your bank account, and you die, your name is still on those accounts. So those are the accounts, or that's the property that a will would have to drag through probate, because they have to change the name on those assets into the name of the beneficiary. That's what a will does. It changes the name from the deceased person to the name of a beneficiary. Now, if you recall, I tried to get you to visualize my empty box, my trust. But what I did with my box is I went over and I took my house and I changed it out of my name individually, and I put it in the name of my trust. Then let's say we move our cars out of our name individual into the name of the trust, and my bank account, I took my name off and put it in the name of the trust. Okay, now picture this, folks. My box has all that stuff in it. What did I leave in my name individually, Alex? Nothing. There's nothing there. So the question is, does my will still work? Well, technically, maybe it could still work, but what is it going to work on? What does it have to drive through probate? I didn't leave anything in a situation to go through probate because I funded my trust. That was my one answer. And I like to give that explanation because it makes sense to me. I took the stuff that could have gone through probate, I put it in a position where it wouldn't, so my will doesn't have anything to act on. The official answer is, when you get a trust, believe it or not, a trust package includes a new will. Now, why would I want a new will? A new will is a safeguard unless you forget to put something in the trust. And the new will would drag your stuff through probate and pour it over into the trust. One of the first slides says necessary documents, and it said a will, or then it said a trust, then it said a pour over will. An estate plan using a trust has a safety net called a pour over will. That will says, hey, this will takes precedence over any old wills. There's the official answer. But I like you to visualize that if you take stuff out of your name and put it in your trust, there's nothing for the will to drag through probate anyway. That's what you want. All right? What's your next question?
Well, the next one's in reference to power of attorneys and how they work at death. I guess this fellow is describing a situation in which his daughter was not able to sign for his mother after death, or was, but
we don't know the exact situation
at death. Yeah.
Great question, and I noticed on one of the slides, the very bottom of the slide in red, and I flew over that. I should have mentioned this. So great, thanks for that question. A power of attorney ceases to exist at death. Now let me put a big period after that. It sounds like in that situation, maybe the daughter, not him, that probably was a blended marriage where the wife had the power of attorney was her daughter, but when she died, the power of attorney stopped. Well, of course it stopped. A power of attorney is used for me in that situation, or somebody, to make financial decisions for somebody that can't make it for themselves. So when they die, it's an all different process. So a lot of people, and kids especially, assume that a power of attorney continues on. So I hear this a lot. Hey, my mom died and I took the power of attorney to the bank so I could write some checks. No. What did the bank tell you? No, it doesn't work anymore because it ceases to exist at death. That's where your estate plan needs to kick in. In a good situation, in that situation, let's say I have a power of attorney from my dad and my dad died. Well, my power of attorney doesn't work, but guess what? I was the successor trustee. So I go to the bank, and the bank account that was in the name of the trust, I can now sign or act on my dad's or the estate's best wishes by signing or doing whatever is appropriate, because I'm the successor trustee. My dad died, the trust didn't. So that's the difference. That's a great question.
Yeah. Well, I mean, we've covered a lot. It's probably all the time, unfortunately, that we have for questions. Obviously, maybe we can do another one of these down the road where we're just taking questions from Learning Lab fans, people that tune in each and every time we do one of these things. But thanks for shedding so much light on such a complex topic. I think obviously our listeners are engaged in this topic right now and worried about it. So, absolutely a blessing to have you on the show.
Always a pleasure, anytime. And folks, get your estate plan in order.
Yeah,
It's really not hard.
One last thing too before we go, don't forget the survey is how you will get in touch with these Learning Lab representatives. If you have questions or you just want to learn anything more about the estate planning opportunities within Learning Lab, fill that survey out. We'll get you in touch with your local Learning Lab rep. The process is seamless, folks. If you're wanting to deal or get your estate planning affairs in order, or just do a double check, sitting down with a Learning Lab rep, they'll get you in touch with their local attorney that they work with. It's a very seamless and also just happens to have the benefit of being socially distanced as well, being totally virtual. And it's just an easy process for you folks. So thanks again for everybody joining us here at the Learning Lab. Thank you again, Brian, for being an absolute superstar on this subject. And we'll see you next time. Thanks, everyone.